So today we're talking about Shoshone Coca-Cola Bottling Company versus Leo Dolinsky. And this case happened in 1966. So to start off with, we're going to go ahead and start talking about historical context for the dispute. So in this case, we're going to go ahead and talk about two previous cases that occurred. We're going to talk about Liggett and Myers Tobacco versus Delate and Southern Arizona York Refrigeration Company versus the Bush Manufacturing Company. So talking about the Liggett case, I want to talk about why this case is prevalent in our case. It's prevalent because a product containing a substance was found in a manufactured product and later caused harm to consumer. In this case, a group of people who tried to take a series of tobacco companies to court over health concerns. And then from the court case, we got the precedent that where evidence is sufficient to sustain conclusion that foreign deleterious substance directly causing injury upon use was an article when it left manufacturer and was not detectable by consumer in ordinary preparation of article for use. This case set the precedent in defense of a lack of contract in that, and I quote, generally manufacturer is not legally answerable for damages suffered through use of manufacturing article in absence of contractual relationship between manufacturer and user, except in the case of damages resulting from use of articles put upon open market, which are themselves inherently or imminently dangerous. In other words, this case shows that even though a contractual agreement was not present between the manufacturer and the consumer, the manufacturer can still be held liable. Further helping the case of the plaintiff's argument that the contractual argument between the manufacturer and Dolinsky is not necessary for the plaintiff's claims to be held up in court. Now, moving on to the next court case. This is Southern Arizona York Refrigeration Company versus the Bush Manufacturing Company. This case involved not only the refrigeration company, but also Bush Manufacturing Company. Bush Manufacturing Company felt that the coil replacement was not necessary, but let the York Refrigeration Company go through with their installation. In other words, the Bush Manufacturing Company relied on the York Refrigeration Company to produce coils for their refrigerators. The precedent set in this case is that, and I quote, rule that manufacture of product, which although not dangerous in itself to life or limb, becomes so when applied to its intended use in usual and customary manner, is liable to persons who sustain injury as proximate result of negligence in manufacture of such product, is applicable to products which are parts to be incorporated in product of one another than defendant manufacturer or seller. In other words, if a preventable manufacturing defect is present, the plaintiff is able to hold the defendant liable for damages.
Moving on to the events leading up to the dispute and the facts of the case, Leo Dolinsky is the plaintiff in this case, and he purchased a bottle of squirt, which was manufactured by the Shoshone Coca-Cola Bottling Company, Shoshone being the defendant. Dolinsky claimed that the bottle contained a decomposed mouse, causing him physical and mental injury. Dolinsky brought a manufacturing defect suit against Shoshone, but Shoshone argued that Dolinsky failed to prove that the mouse was in the bottle when the bottle left the hands of Shoshone. The mouse had hair on it when the mouse reached Dolinsky. Shoshone stated that if there was a mouse in the bottle while the bottle was at the Shoshone plant, the mouse would not have any remaining hair given the solution and heat that Shoshone used to wash the empty bottles. Shoshone also argued that Dolinsky had the burden of showing that there was no opportunity for someone to tamper with the bottle after the bottle left Shoshone's hands.
So next we're going to talk about the legal issues involved with this specific case. So to start off, the plaintiff is suing the defendant on terms of physical and mental injury that he occurred after consuming the squirt bottle. More specifically, when we actually go into the court, he's looking at 3 different terms of liability: implied warranties of quality, negligence, and strict liability. Obviously, as we just found out in the last slide, 2 of those were dismissed at the end of the case. So now we're down to just strict tort liability. With that strict tort liability, the damages were fixed at $2,500. And after consumption of the squirt, the plaintiff visited a psychiatrist and was given anti-nausea pills just due to the sickness he was having. And 2 years later, at the actual time of the trial, he still opposed soda strongly, still didn't drink it at all. And just due to the evidence from the past case, he had a conditioned reflex from his past experience. So in terms of that, and when we look at the damages, we cannot actually conclude that the damages were given out under the influence of passion or prejudice in this case.
So how the dispute was resolved, Dolinsky was rewarded $2,500 as a result of this case. And the main deciding factor behind this outcome was the fact that Dolinsky had developed an aversion to all soft drinks after this incident that could last for the rest of his life, and was told this by a psychiatrist. In the trial, the court allowed it for a different psychiatrist to speak on behalf of the one who treated Dolinsky, which made Shoshone upset, resulting in them wanting to overturn the ruling. However, in the case Kitzelman versus Rotzan had a similar situation in which the conclusion to that trial allowed for qualifying physicians or surgeons to testify as a medical expert. Therefore, Shoshone needed to pay Dolinsky in full for the damages caused.
The conclusion for this case is this case was instrumental for Nevada because it set precedent in favor of the plaintiff under strict liability law. The court ruling set the precedent that one who places upon the market a bottled beverage in a condition dangerous for use must be held strictly liable to the ultimate user for injuries resulting from such use, although the seller has exercised all reasonable care and the user has not entered into a contractual relation with him. And we took this straight from the Shoshone Coca-Cola Bottling Co. versus Dolinsky case. And manufacturers are liable for manufacturing defects even in the presence of reasonable care.